And thank you so much for tuning in to Morning Live. Now, Public Protector Busisiwe Mkhwebane says that she disagrees with the ruling of the North Gauteng High Court on her investigation into the Estina Dairy Farm. Now, she will now apply for direct access to the Constitutional Court, and this after the North Gauteng High Court set aside her report finding it unconstitutional and invalid. And the matter has been taken to the court by the Council for the Advancement of the South African Constitution, CASAC, and the Democratic Alliance. And they had called the report a whitewash and said that it failed to hold to account those responsible for the theft of almost 200 million rand of public funds. Now, to discuss this matter further, joined here in studio by Lawson Naidoo, the Executive Secretary of CASAC, and also from our Pretoria studios, we have the Public Protector Advocate Busisiwe Mkhwebane. Thanks to both of you for availing yourself this morning.
Thank you.
Ms. Naidoo, let me start with you. You, of course, brought this matter before the courts, and obviously you see this as a victory. But explain to us the finer nuances behind you bringing this to court and also what this ruling means to you.
Well, I think the first thing is to note the timing of issues. This was a complaint that was initially laid in 2013 by a member of the provincial legislature in the Free State. It had been investigated for over 4 years before a report was published in February of last year, after the Gupta leaks had descended upon South Africa. And evidence came out from those Gupta leaks of information relating to the involvement of Gupta family and their associates in this project, and how the money was funneled to them for including amongst other things the infamous Gupta wedding at Sun City. And the Public Protector seems to have ignored all of this information that was in the public domain and narrowed down the focus of her investigation to focus on procedural irregularities, and didn't follow the money, nor did she follow the information that was publicly available. So we felt that this report was really a whitewash and needed to be challenged in court, which is what we did.
Advocate Mkhwebane, you said you were rather astonished by Judge Tolmay's ruling yesterday. Why is that?
I'm rather astonished because she wrote a letter last year in October after the hearing that she wouldn't proceed with the judgment in the matter, acknowledging that the facts and the merits of the matter are linked to the judgment of the Constitutional Court, which we are still awaiting. Actually, I mean, it's astonishing for her to even rely on the facts of that judgment, which is before court. And at the end of the day, I will have to consider, in fact, I said I'm considering appeal or direct access to the Constitutional Court. I must indicate that whatever Mr. Lawson is saying, or Naidoo is saying, is that the investigation was complete when I joined as the Public Protector. My predecessor investigated the matter. And I mean, it's so embarrassing for them to even rely on the provisional report, the very same provisional report which doesn't implicate politicians at all. And again, we've been through this matter, and I appeared before the Portfolio Committee where I explained that how this matter was investigated. And Rule 53, all the records is clear that the investigation which was before the Public Protector Free State Office was investigating the complaint lodged by the DA. So, and I agreed that I will proceed and investigate the involvement of the politicians and the issue of the beneficiaries.
So did you eventually do that?
I'm busy doing that, Sakina. I was in Free State at the beginning of April, and I was having hearing with all the beneficiaries. And I must indicate that Mr. Mahashula was interviewed last year, and we will be interviewing Mr. Zwane and Ms. Kabate, and even the mayor, who was also said to have been involved in the project.
So You said that you will either apply for direct access to the Constitutional Court or you will take this matter on appeal. On what grounds? Because you also indicate that you disagree fundamentally with some of the aspects in the ruling. Which are those?
I won't deal with the merits of the matter, Sakina. As I'm saying, I'll have to meet with my legal team and then we will agree on the strategy to take. But on the face of it, I don't agree with the judgment. And I mean, the very same judgment which has been handed over, the merits of the matter and the arguments which were lodged there. I mean, they lodged their arguments based on the fact that I didn't rely on or took into consideration the Gupta leaks, which it was very clear in the report that I mean, that matter will be handled by the State Capture Commission, the very State Commission which is as a result of the Public Protector's remedial action.
But does that preclude your office from dealing with the Gupta leaks?
The Gupta leaks, it's information which we will have to investigate deeper. Remember again, the Gupta leaks, there's a lot of issues relating to the credibility or the authenticity of those Gupta leaks. If we use any information there, the way we conduct our investigation, Sakina, we don't just take information from the media. We don't just rely on that. We'll have to subpoena and interview the drafters or the people who collated the information for us to be able to determine indeed whether the information they have relating to the Vrede matter. But I must also still hasten to say that the investigation was purely on issues relating to maladministration, the way the resources were utilized, and also we relied on the Inspector General's report of the National Treasury, where there was a forensic report which was conducted. And on that particular aspect, we have taken note of that particular investigation. So I think we will have to deal with a lot of issues which we are picking up on the judgment.
Lawson Naidoo?
Well, I think the advocate has been disingenuous here. Firstly, in relation to the timing of the judgment, Judge Tomei did indicate to us in December that she was awaiting the Concord ruling in the ABSA matter, but that relates specifically to the issue of the personal cost order that we've requested the court to make. The facts of the two cases are entirely different, and so the timing of the judgment has got nothing to do with that. Secondly, Advocate Mkhwebane has never explained why she altered the provisional report in material ways, which made far-reaching findings against senior politicians implicated in this project. She simply deleted those findings and remedial action without any explanation whatsoever. And thirdly, she says that, after going to Parliament, to the Justice Committee last year, when they asked her to pursue the matter of the politicians, it's more than a year later. And she's only just interviewed the former premier. She's only just met with the beneficiaries. What has taken so long? Why is this not a matter of urgency? And then she talks about the Gupta leaks. Yes, it's in the public domain. If she needs to subpoena people, why hasn't she done so? She simply hasn't taken any of that information into consideration in her report.
Before I get the Public Protector to respond to that, you say that she materially changed some of the aspects of the provisional report. Give us an example of that.
Well, we only came to know of this, Sakina, when the Public Protector was required in terms of the rules of court to provide us with the record of decision, the Rule 53 record, when she had to make available to us the provisional report. And we then discovered that there were remedial action that related to the former Premier of the Free State, Estina Dairy Farm. And in her final report, Advocate Mkhwebane says that the implicated person, Mr. Magashule, should institute disciplinary action against others. I mean, that's an astounding finding to make when somebody who's directly implicated, who you have not further investigated, is then charged or then given the responsibility of taking disciplinary action against officials. And to our knowledge, there is no evidence available that any such disciplinary action has actually been taken, and the public protector appears not to have been interested in following up on that.
And when you say Mr. Magashule is directly implicated, how so?
Well, we know from the Gupta leaks that the whole scheme of this project was cooked up by Mr. Magashule, Mr. Mosebenzi Zwane, and the Guptas in order to funnel over 200 million rands of public funds to various Gupta entities, including paying for the infamous Sun City wedding.
Advocate Mkhwebane?
Hi, Sakina. It's I will make the provisional report public. I mean, Naidoo is just talking what is very, very wrong. It's not the case. The provisional report, there's no way where it's mentioning that the Premier is implicated. The provisional report deals purely with the officials, with the Tabete, the HOD, with the CFO, and it's even, my legal team even argued in court that the report which I issued, I included all officials who were involved because it was also the legal senior manager in the Premier's office who was involved in the drafting of the report. So now the way you are mentioning it, Mr. Naidoo, that's not how we investigate. I mean, you cannot rely on Gupta leaks, and the Gupta leaks will be dealt with at the commission where we were dealing with the maladministration. So there's no way. I'll make that provisional report a public document, and as I indicated, it has no legal status, that document. It was relating to the very same officials, how to refer the matter to the SIU, to the Auditor General. I mean, it was referring to those issues. So for him to say we have removed the implicated politicians is not the truth. It's lies, and I will make that document public for the public to read that document openly. And also what we did in our papers, we showed the difference between the provisional report and the final report. And Sakina, for your information, that provisional report has no standing. It's a draft. I mean, I've even explained that for judges, they will understand when it's a full bench, one judge is drafting, forwarding it to another judge for them to apply their minds. So for them, it's disingenuous to just say, I must just take the very same final report. If I issued the final report or that provisional report, it will still be the same issue we are facing today, because you would be saying it's a whitewash. But then again, I think CASAC, your role, you advance constitutional democracy, and I think we should be working very closely and making sure that the people at the grassroots are assisted with issues of maladministration. Even with this investigation we are busy with, if you are working with us, we requested DA. Mr. Maimane, he came with the beneficiaries. I requested his assistance. Can you make sure that we get the statements? That never happened, but it's fine. It's water under the bridge now. We are proceeding with the investigation. And for your information, we are not just sitting or focusing on one investigation. We have a lot of investigations we are focusing on. I mean, you are then now also involving yourself in another space where it's like pushing this narrative that this public protector, there's a lot of finding or matters set aside by the court of law. The way we operate, again, that report, set aside the whole report. There are officials who are implicated. The HOD action was taken against him, and then there was disciplinary hearing against the CFO. So they informed us. And you are even saying Judge Tolmay didn't inform you. I have a letter from her where she was saying she won't proceed with the judgment. And then all of a sudden, then there's a change of heart and sending it. She wrote to me.
Okay.
I have that letter.
We are running out of time.
I did not say that Judge Tolmay had never written to us. I said that the reasons Judge Tolmay gave, because she did write to us, of course she did, and said that she would wait from the Concord. And in her judgment yesterday, she starts her judgment by saying, explaining that background and saying that given the time that has passed, she feels that she now needs to release this ruling of hers, but she's held back on the aspect of the ruling that relates to our request for a personal cost order against Advocate Mkhwebane because of her not disclosing initially the provisional report. And of course the provisional report has no legal standing, but she has not explained to the public nor to the court why she changed the findings and remedial action in that provisional report.
Okay.
And the court and the judgment yesterday deals with that quite seriously.
We're running out of time. So as CASAC, you've come forward and you've said the public protector should be relieved of her duties. So explain to us why, and I'll get her to respond to that.
Well, I think because of the various court judgments that have now come down in the Absa Saab matter as well as in this case, which really states quite openly and blatantly that the court's view is that the public protector does not understand her mandate, does not take it seriously. She was found yesterday by the High Court to have failed to fulfill her legislative and constitutional responsibilities. She narrowed down the scope of the investigation, apparently deliberately, in order to avoid implicating senior politicians, and that's certainly not the job of a public protector who is out there to ensure our rights as ordinary South Africans, and she's failing in that duty, and Parliament now needs to act on this.
Advocate Mkhwebane?
Naidoo, I think you need to focus on us helping the public instead of busy focusing on removing the public protector. And there's a lot of judgments which are in our favor, several of them, even at the Supreme Court of Appeal. No judge was removed as a judge because the higher court has found against them. So there's no basis for you to raise that. And with one judgment, the CX or the Absa matter, and you know very well in that judgment, no facts were dealt with, no merits were dealt with in that judgment. I mean, the fact of the matter is two judges, Judge Davis and Judge Heath, found that loan to be unlawful. But interestingly, the focus is not on that. The focus is on all other issues. I mean, there's various judgments there. The Eastern Cape High Court found in our favor in the Nelson Mandela matter. The very same Pretoria or High Court found on our favor in terms of the matter of the former MEC of Limpopo and the HOD Duplessis.
Lawson
So
Naidoo?
I don't understand why you now come and just say on
the
one
issue here
matter.
is not about...
And the matter is still at the Constitutional Court.
The issue here is
the
not
very
about
same
whether
matter of
courts are found in
CX.
favor or not, but the real issue here is the courts have pronounced on the integrity of this public protector. It's not just
And
saying
that matter is before
it's
the
not just saying that you were
Constitutional
wrong in this matter, which happens with courts overturning judgments of lower courts. But this is these are judgments that attack the integrity and the capacity of this public protector to hold office, and that's the fundamental difference.
That judge, and the higher court will differ to that. If you are a judge, you focus on the merits of the matter, you are objective, you can't be subjective. So the higher court will find differently on that matter. So I think using the courts by some organizations like yourself, possibly to deal with the integrity of the public protector, it's so unfortunate. I think let's focus on protecting the public against maladministration, against corruption. and I'm investigating the politicians. And I said I'll avail that provisional report for the public to decide. What did I change which implicates the politicians? There's nothing, nada.
Why did you not interview the beneficiaries before releasing your report if you're so concerned about the public?
Exactly. I requested the DA.
Why must the DA do your job?
I requested, no, because they are the complainants. And they can do the complainants.
They're not responsible for investigating.
That they need to give me the statements. And unfortunately, when I was following up, the very same DA is saying, release the report, we cannot wait anymore. The matter will be investigated and it will be out to the public for them to know what happened and really happened in that particular matter.
I'm going to have to call time on it.
Only on the prejudice of the complainants.
Well, thank you so much to both Lawson Naidoo, Executive Secretary of the Council for the Advancement of the South African Constitution, and Public Protector Advocate Busisiwe Mkhwebane for talking to us about the ruling yesterday regarding the Vrede Dairy Farm, which was, of course, set aside by the Gauteng High Court. With that, it's time for the latest news with Leanne.